Hey, Daniela here, and welcome to the Spa Marketing Made Easy podcast. If you offer medically assisted weight loss in your practice, first, what a wild year it's been. And second, I am so glad you're here because my friend Courtney is going to shed so much light on this topic from a legal perspective. There's so much incredible information in this episode. I really just want to jump right in. So I'm going to read Courtney's bio. I know you'll love her as much as I do, and I truly hope that this episode helps you. So Courtney is a corporate attorney turned medical aesthetics insider who knows the industry from both sides of the syringe. After serving as founder and legal architect of a fast-growing aesthetics company, she made the pivot from building her own to helping other providers build theirs, minus the legal landmines. Now, as the founder of Court Approved Aesthetics, she brings attorney-trained tools, AI innovation, and hard-earned insight into the med spa world. She's here to share what she's learned, sometimes the hard way, so that you can grow with confidence, clarity, and a whole lot fewer compliance headaches. She's incredible, and again, I hope this episode helps you. All right, Miss Courtney, welcome to the Spa Marketing Made Easy podcast. I'm so excited to have you here. And you are someone that I categorize as a fast friend because when we first, it was it Paulina or Jacqueline?
Yes. Yeah, Paulina.
Okay, so Jacqueline introduced me to Paulina. Paulina introduced me to you in the web of our small industry. And we got on the phone and talked about Dolly Parton and our kids for 25 minutes and then had to go.
Yeah. And it's so funny. It's like one of my most favorite meetings. And I love when meetings go that way because my husband at the end was like, how did it go? I'm like, how'd the business meeting go? I'm not sure. I didn't attend a business meeting, but my really great friend, Daniela, that I've known for years, that I just met. And that's like my most favorite meetings because, I think so quickly in the industry and as an attorney, people come into this with a lot of expectations. And so one of the biggest compliments that I received a few times is that I'm someone you feel like you've known for years. You're like, that's amazing because that's a lot of, perceptions and expectations that are just broken down. Because I think people, number one, or when someone tells me I'm fun, because attorneys are not fun and they're not personable. So
I'm married to an engineer,
yeah.
And engineers kind of have their own category as well that like attorneys have. And I fully agree that like I wouldn't look at you and just peg you as an attorney, but you're different. Like you're a spa owner, you're a business owner, you're like there's all of these things. An attorney is just like a small piece of you as a whole. And so, yes, I'm sure that you can get into that very analytical mode and you can get into that space, but there's more to you than that one little thing. So,
yeah, I completely agree. One of the things I say pretty often is that compliance is great, but compliance actually lives in your operations. So I can spout the law and tell you what it is all day long, but it still leaves you the question of like, okay, now what? So wearing those hats and knowing, what in the trenches of being a business owner and a med spa owner of what does this actually look like? Okay, here's the statute, here's the reg, here's the flow chart. Now let's put on our business owner hat and be like, how do we make this make sense and make it not have a million different, gates and funnels, and we don't have team burnout. And that's my favorite part of the job is taking like the legal, but then putting it into action and putting it into a way that actually makes sense and doesn't cause a burnout and leads to like more profit in businesses.
So talking about how to make this make sense, that really leads us into our topic today very well. We're talking about GLPs and what the heck is going on with them. There has been this massive growth over the past couple of years where we've seen practices, attract a whole new demographic of patients. We've seen phenomenal results. We've seen just increased profit margins. It's like a win across all boards. And we started this year in our community talking about medically assisted weight loss and GLPs and how we're, if you're not on that bandwagon, then get in that bandwagon because it's the thing right now and it's profit and all of the things. And then we had tirzepatide taken off the shortage list. We had semaglutide taken off the shortage list. And there's practices that are getting cease and desist letters. Nobody knows what to do. And so many people in our industry, or at least in our community, were rule followers, we're people pleasers. There's these we're recovering people pleasers, I'll say. And we want to make sure that we have everything lined up in a row, but it's scary and hard to understand what is the right thing to do. And so when you suggested this as a topic, I thought, okay, I am not an attorney. I'm not going anywhere near that conversation. Like I know, it's like that is out of my scope. And let's bring somebody in that, you're in it. You have a med spa, you are an attorney. So you teach compliance to other med spas. So I want to hear your perspective. Where is the place that we should start with this?
Yeah, so I did an hour and a half master class on this topic. So anytime someone asks me to speak on it, I'm like, let me condense down an hour and a half master class. Because one of the things that I am so passionate about is I want anyone who works with me, who listens to me, who gives me the time of day to walk away and to be more informed than 90% of the rest of the people in the industry until they can convince the 90% to come, get the same lecture. Because I could give you the quick and easy answer, like, 3 lines, here's the answer for your problem. But then you don't know the why. You don't have any type of protection or reassurance. And what I found is people want the answers, but what they actually want is like put their head on their pillow at night to feel confident in the answer. And I had a meeting with a new potential client a couple of weeks ago, and the meeting started with, I've asked this question to 2 different attorneys, and I've received 2 different answers. And I was like, well, I might give you a third answer, but I'm going to give you the backstory first, which a lot of people in the legal world, when you're hiring an attorney, you don't want to pay someone $500 an hour to spend an hour and a half talking about this topic to help you understand the answer. But in my opinion, it's almost as important as a business owner to get that back information than the answer itself. So I really like to start with, like, how did we get here? So we can get our arms around the whole topic. So one of the things I hear pretty often in the world of GLP-1s is, well, we were able to compound these before. And so that's, the first thing that, and especially in the master class that we walked through was, yes, this is the normal trajectory. So compounded drugs are then picked up by pharmacies and manufacturers, and manufacturers pour boatloads of money into getting them FDA approved. And then they are given a patent. They are given trademarks over their name and the image, and they have a trademark on the actual like syringe that's used. And that is what pulls them from being able to be compounded. But absolutely, these medications you were able to compound them prior to a big company picking them up, pouring boatloads of money into it. So,
and I've heard people say, well, they're adding B12 or they're adding, something else that modifies it some percentage. And so they feel that it should be something that's reasonably different. Is
sure.
that true or is that not true?
Yeah, it's the material copy argument. So now that the drugs went on the shortage list, then going on the shortage list allows compounders to compound it. Everyone knows they came off of it. And now we are in this, okay, we know we cannot make the identical copy, which we were allowed to while they're on the shortage list, but what can we make? And when I say we, as in the compounding pharmacies. So if we could draw a chart, you have Eli Lilly, Novo Nordisk up at the at the top of this chart. The FDA is underneath them, and then the compounding pharmacies. And I have a chart that kind of depicts this. there's no line that connects Novo Nordisk to the compounding pharmacies. You have to go through the FDA. And there's actually a case on this in Florida where essentially Novo Nordisk sued, it might have been Eli Lilly, one of the two, sued a compounding pharmacy. And the court essentially says, like, sit down, not your job. That's the FDA's job to regulate compounding pharmacies. So what a compounding pharmacy now is trying to get around is that they are not making a material copy of this medication. So they are saying adding B12 or B6 or glycine is another one. That is, it takes it out of the material copy requirement that the FDA has. Ultimately, what I tell my clients who are practitioners is not really your problem unless you're compounding, because you're not making any material copy. So when we get to practitioners, the other side of that chart is at the top, you have your governing body, whoever it is, your board of medicine, your board of nursing, your board of cosmetology, providers. That's who oversees providers. But again, there's no connection between compounding pharmacies to the providers other than ordering. There's no connection from Eli Lilly to the providers. Providers are responsible to their boards. That's who oversees their license. And I spend a lot of time on this topic because one of the things I hear and I've heard is that, well, what if we just don't call them patients? What if we call them clients? And instead of giving prescription medication, we're giving access to material that can, insert whatever.
Over the counter. Yeah.
Yeah, like it's not. I'm like, no, I want you to lean in as heavy as you can, and I will stand in front of you as we say this, that this is the practice of medicine. We are prescribing medications to treat patients for various reasons, and we are using our medical judgment to create those prescriptions. So we believe that someone needs this version of medication with B6 for the following reasons. We believe someone needs this version with B12 for the following medical reasons, because I do not have any say in the practice of medicine because that is not within the scope of my license. Novo Nordisk, Eli Lilly have no say in the practice of medicine. That is not within the scope of their license. So they cannot come in and tell you what you can and cannot prescribe to your patients. That is up to the board of medicine or the board of nursing or whatever board you are responsible to. So one of the things, like, again, I spend a lot of time like on this exact slide to say, at the end of the day, what we're talking about is your liability is good old fashioned negligence. Like, are you treating patients the way that you believe they need to be treated?
Let me give an example and you can explain, because you mentioned in the beginning, some of these drugs are covered by patents or trademarks. And if I'm a spa, like my company, Atto Aesthetics, is trademarked. So if somebody else use that name, I could send them a cease and desist letter. Is it not parallel that Eli Lilly or any of these other companies that own these patents or trademarks, can't they come after a spa using that so they wouldn't be able to use the name Ozempic or Moreno or anything like that. But if you use the name semaglutide, or is that the generic, like that's generic enough that we can use semaglutide or tirzepatide?
Mm-hmm.
And so as long as we're only using those names, that's not what the trademark is protecting.
Correct. Yeah. So the trademark so they have a patent over the formula, and the argument for like the formulation, that is, if you can, divide in that kind of flow chart, that is on the side with Eli Lilly, Novo Nordisk, FDA, compounding pharmacies. That is where the patent lives. Now, you can have some connection between the practice, the provider, and these manufacturers, Eli Lilly, Novo Nordisk, if you are infringing on their trademark. And that's one of the things I tell everyone is there's nothing I can do to help you on that. And they have absolutely filed lawsuits for people saying, we prescribe semaglutide, aka Ozempic, or we prescribe the FDA approved version of semaglutide. No, you don't. You prescribe the compounded version of semaglutide. The FDA approved version of semaglutide is Ozempic. And so they're saying then you're infringing on their actual trademark, what they've put in all the money into. And actually, there's a case that was just filed within the past month in California where they are arguing it's against Mochi Health and Mochi Health's various entities, where they, on their website they advertise that they offer the compounded version and that they offer the FDA approved version, the semaglutide, the Ozempic. But what they actually discovered whenever they were doing, or it's their belief, is that that kind of was like a bait and switch situation where you put it on your website. Sure, it's an offering that you offer, but you never ever prescribe the actual FDA approved version. You always prescribe the compounded version. And so you were just kind of riding in on the coattails of all of this money and research put into these trademarked, easily recognizable names. But then the moment you got a patient in the door, you switched them to the compounded version really quickly. And so that lawsuit is not over that they prescribed a compounded version. It's that you used our trademark to draw in traffic, and then we didn't benefit from it at all. So like if you're going to use anything recognizable to us that we own, we have to benefit from it in some way in the trademark world. So I tell people like that's the same case for Addo Aesthetics, Ford Motor Company. This is not new to the practice of medicine. If a company has something that they've invested a lot of money in and they protect it, whether that be Nike, let's do it. You can't just put let's do it on everything. Because it has such brand recognition and that they seek to protect it. And so, yeah, you will get a cease and desist if you or probably a lawsuit. I know quite a few people who've gotten a lawsuit, one here in Tennessee, because they were using the AKA semaglutide, AKA Ozempic in their marketing.
Can we say medically assisted weight loss?
Yes.
Okay. So what happens if you get a cease and desist letter?
So I've looked at a few, and what I help practices do is decide, is this worth it to you? I cannot do anything, literally nothing, to protect someone from getting sued. And I tell you, this is my job. I have a license to be skeptical. It's what they put on my diploma that's hanging behind my license to be skeptical and cynical. If you have something related to your spa on the back of your car, I would be wary of every single person who drives next to you on the interstate and slams on the brakes too hard in front of you because they might assume that you're a business owner who has lots of money. So there's nothing I can do to protect you from getting sued. But what we can talk about is what ultimately your liability would be. And then in that, so we have, the liability is the legal piece, but from the timeline of being sued to liability, in that is a huge business judgment. So I have clients who it's only 10% of their practice. Medically assisted weight loss or any type of weight loss program where these drugs would be involved is such a small portion of their practice. Like, is that business judgment of hiring an attorney to respond to a lawsuit or hiring an attorney to do something, is that worth it to you? And I have many who have said, no, we really didn't even have like a full program. This isn't even our passion. We're really passionate about more, skincare and longevity type health, and we can just pivot our business model. But then I have some that it is 80 to 90% of their practice.
Yeah.
And so yes, that business judgment decision lives between the lawsuit being filed and liability. So, and that's, I think, the biggest piece that practices have to decide at the end of the day. Because if you're just prescribing the medications, you're falling within your scope of your license. I'm not really concerned. I've reviewed the demand letters. The demand letter argument, they have 4 points, and I have I think it's nice video discussing this. But the argument they make for medical practices is so outlandish, where they're trying. I mean, it's a far-reaching argument. And so I'm not overly concerned with providers just prescribing the medication within the scope of their license. And if they feel confident standing in front of the board of their peers, the board of nursing, the board of medicine, and defending the way that they medically treated a patient, which they should every single time they medically treat a patient, then I'm not super concerned by them. Now, they probably will get a letter. So you have to decide what to do. I have a lot of clients who are have hired an attorney to send back a letter that essentially says, this is the practice of medicine. We are acting within the scope of our license. We are getting drugs from one of the sources that we are allowed to, which is a 503A pharmacy under the FDA as a provider. So, we're not getting drugs from overseas, or we're not getting drugs from not vetted sources. We're getting them from a state licensed facility, a pharmacy, and that we are acting within our scope and prescribing them according to our clinical judgment. Now, the pharmacy holds a different bag of liability because they hold the identical copy bag of liability. The practice owner itself owns a lot of the liabilities around like marketing. So how we're making sure that you aren't
You're using
inferring.
the correct terms and
Yes.
language.
Yes. Yeah. So practice owner liability is about scope and making sure that they're treating patients according to what is a reasonable judgment in medicine, and the marketing piece of it, and making sure that you're not infringing on any trademarks. And then the compounding pharmacy holds the patent liability.
So do you think the next phase that we're going to see, if this is like a long-term strategy with these pharmaceutical companies that have invested so much money, they're kind of, getting rid of some of the fringe by just scaring people with the cease and desist letters. Is the next strategy step for them actually going after the compounding pharmacies? And okay. And so
I think the next strategy is going to be, they haven't had a ton of success in going after the compounding pharmacies. Like I said, in that case in Florida, the judge was like, this is the FDA's job. So what I've seen for next strategy so far is that compounding pharmacies are putting pressure on the FDA to protect its patent. And to be truly transparent, I feel really conflicted because I am a mom of 3 children, and I want my children to grow up in a world where we are continuing to advance medicine. And that is why we have patents. That's why we protect people for their investments. So I definitely see it. I also see the tremendous benefits to patients themselves. I just met with a client who is prescribing very, very small doses to one of her patients who has atypical bulimia. And it is now helping. They're using it in conjunction with some therapy, but it's helped kind of quieten some of the issues that manifest in a more physical way so they can deal with the issues that are more internal. And I mean, that's real people, real problems, real medication helping out. So I see it from both sides, and I really do understand where kind of the practice owner is coming from, even just strictly on a clinical side, but then I see it on Eli Lilly's and Novo Nordisk side too. But what I've seen so far is putting pressure on the FDA to go after compounding pharmacies. And the newest is that now these manufacturers are sending letters to state boards, because again, the state board is who the provider is responsible to. So if the state board says it is not okay in this state to prescribe these compounded medications for these reasons, well, now the provider has direct guidance that says, I can no longer prescribe these medications. So
would that be because they're using them off label, or is it something that they're trying to do within scope, like only MDs are able to do this? Or because like, how could they say that if another MD could prescribe it and get it from their pharmaceutical company, right?
yeah, yeah. So the letter is actually a letter to the Georgia board, that was sent by, I think it was Eli Lilly, but it might have been Novo Nordisk. But both companies are making the same argument that compounded drugs are not safe. So you should not allow, even though but providers prescribe compounded drugs for all types of cases. But we should not allow compounded drugs in this specific instance, or you should not across your state. you should essentially say if you prescribe a compounded drug and one of your patients gets hurt, it's considered like de facto negligence according to the board. And so they're trying to put pressure, and they've out in their letter they've outlined that they do have a patent, and they've outlined like the history, but really leaning into like these medications aren't safe for patients. That's the stance, and that's how they're trying to appeal to the board. And I explained it to some people that I work with. I try to use as many examples as I can that are totally outside out of left field, but to make it make sense. So like I said, I have 3 children. And so what I said, it's the equivalent of I would be the board in this case as their mother. And we all know children love to tattle on each other. And so one of my children is acting like the manufacturer, and they are tattling on not just one of them, but they're like, look at those compounding pharmacies. Look at that. Mom, did you see them? The compounding pharmacy and the provider, and they're teaming up together and they're causing all kind of mischief. You should do something about it, Mom. And so now, as the board, the mother in the situation, I have to figure out what I want to respond back to my child that's tattling, because they have no oversight over the other two. They're not the parent. And then the 2 children who are acting independently, but allegedly they're colluding together. What I want to do about that, and that's where the board is at this point. We've had a few boards, Washington. There's one in the South, Mississippi, I believe, who have said no more compounded semaglutide or tirzepatide within our state. So I think that's the next kind of route that the manufacturers are going to go try to appeal to the boards.
And then I know this is very speculative, but do you believe that these manufacturers are going to try and sell their FDA approved, the Ozempic or Mirena or whatever, directly to med spas? Or are they going to go directly to patients? Because what I've seen is that they're selling directly to patients at the same price that they would be selling to medical spas.
Mm-hmm.
But there's pharmacies. I personally know people that have bought Ozempic or these actual name brand drugs online without having to have a good faith exam, without maybe it was a bad website. I don't know. I don't know all of the details there, but how are people getting it online without having medical oversight in any way? That seems like a whole other can of worms. That's what's happening here?
Yeah. I mean, and that's one of the things I talk about pretty often is this is why we can't have nice things, because we've got people who are going off into left fields. We're not talking about the provider who either sees their patients in person every single appointment, or they see their patient in person once and then they see them again, in 6 months, but they have some checkups in between. We're not really talking about people who are doing it objectively the right way, and that we've seen it in other areas. We've seen it in other types of management for even something as simple as acne treatment, where you go in and you get an assessment and then you're prescribed some antibiotics. Let's see how it works for you, and then we'll take down if you had any symptoms, have you had any improvement, and then we'll pivot your treatment plan. People who are doing it kind of in the fashion that we're all used to in medicine, we're not really talking about them. But what's going to happen is what always happens is that, and I don't like to use the word always, but in the legal world, it is what always happens is we kind of have this overcorrection where we are actually targeting the people who are doing things wildly inappropriate and wrong. Yes, Mochi Health is one example of that, doing things wildly incorrect. And then people who are doing it actually okay, and they end up getting caught up in the storm for all of it. So I don't know the specific website. I know of a few where you have a medical director who's licensed in all 50 states, and they have one mid-level, and the mid-level is doing a good faith exam, not in real time, and then it's getting shipped straight to their door. I mean, I will just tell you, I come from a place of being a business owner and an attorney, and so I understand that operationally we're in the business of risk. Business is risk, and if you wanted no risk, I would tell you to shut down your business because that's just where we're at. And so you have to make like a risk assessment and risk tolerance in each one of these decisions, which that's where I was saying, between liability and the lawsuit, there's a lot of business judgment that exists in there, and you have to really weigh the risk associated to your business. Is it worth it for you? Not from a liability standpoint, but just from like having to hire an attorney. But all the clients that I work with, we don't really risk, I don't allow a lot of like risk of compliance. So what I've seen from the way those websites work is we're not operating compliantly. We're operating only using our business hat, and legal and compliance lives in your operations. It has to. You can wear them each at once or both simultaneously, but you don't get to just throw one away and feel like we're making as much money as we possibly can out of this, because that's when we've taken the medicine out of the corporate practice of medicine, and we're just operating as a corporation, like we're selling widgets. And even me, someone who's not a provider, my clients don't go down that route. You don't have to. You can be a very, very profitable, very successful med spa and be totally compliant. And like I've seen it happen over and over and over again. And you'll be standing at the end.
So what do you think when you're talking with your practices that it's, 60% plus of their revenue is medically assisted weight loss, and they are doing this, having them come in weekly for weigh-ins and having the check-ins, and they're doing it with a lot of care and intention. What advice are you giving to them? Is this something that, in the next 5 years you think is going to dwindle out because of all of this? Should they be transitioning into HRT? Should they, what is I know it's all risk, but gosh, there's some places that are doing multiple seven figures just on.
Yeah. Yeah. Actually, I know. So the favorite thing for an attorney to say is it depends. And really, in this world, in the GLP-1 world, I really don't feel it depends. I really feel so sure in the way to do that. There is a way, with a couple of options. Once you go down that single path, there is a way to do it that is compliant for now, and that we can, if your state board decides to change their opinion, then of course we need to shift. We need to pivot some portion of your industry, some portion of your business to have another offering to your clients and be ready to pivot should you need to. But one of the biggest things that I have to help clients overcome is their mindset around GLP-1 medication. So what I saw and what I've seen for the past few months is that people were charging it's the perception that they were upcharging medication, when in all actuality they were not. They were just not sending an itemized bill. So if you tell me that you have a patient come into your office every single week, let's just take that for example. If I was in an actual office, well, my insurance copay is $40. So I would have a $40 charge every single week when I came into that office. So $160 of your upcharge, take that off. Okay, now take the cost of the medication off. What are you left with? $20 you made on it at the end of the day? That is not an upcharge. That is having, covering the staff who injected, that's covering the alcohol swab. Like, that is totally administrative fee. I'm not sure that you, at the end of the day, like made a ton of money on that procedure. But because we were doing what I have, witnessed is it was just one single charge. We were doing double the cost of the medication. That the practice owners believe that they were truly making so much money on the medication. It's like, yes, but what you haven't put into that whole equation is you. Nothing about you. And let's break that down and add all of your value into it, because whether you want to place a dollar on it or not, I will force you to place a dollar on it, put my arm around you and make you say that like a minimum, any practice I walk into, it's a $40 slap every single time. So do not tell me that you're worth less than that. And that's the negotiated insurance rate. And don't tell me that you can't justify that. So what I help practice owners do is separate the two out. What is your medical advice, your medical program worth? What value do you bring to patients? Do you have nutrition help? Are you running their labs? Are their labs included? Are you doing follow-ups? Are you offering other services in addition to it, like helping with volume loss, and you're giving them like a full patient assessment? How often are they coming in? Let's put all of that down on paper. And then you have the medication over here to the side. Like, charge them what they would be charged for the medication, sure. But what does it cost to be a patient of yours? What is your experience that you bring that's so different from everyone else? Because I can go spa to spa and get the 503A compounded version of semaglutide, but I cannot go spa to spa and get you. So what is that worth? And that conversation makes people very uncomfortable because they're like, well, no, they don't need to pay for me. I'm like, you are it.
So if we take that concept into med spas are cash basis, and that's why so many providers move from medical into cosmetic and go into, and I say medical and cosmetic in the term, when I used to work at plastic surgeons' offices or derm offices, there was the medical side where we did skin cancers and skin checks and those things. And the cosmetic side is what we kind of overall look at as medical aesthetics, right? So we build completely different on the medical side, just like you were saying. But on the cosmetic side, wouldn't things like Latisse, that used to be a glaucoma medication, or even the neuromodulators that we're using that had a medical purpose, whether that was for migraines or incontinence or hyperhidrosis or any of these types of things, wouldn't we then too have to bill in a completely separate way?
So, in this business legal hat, so if I'm putting on a legal hat, then we should be, yeah, then the answer is yes. The difference between the business and legal hat for me is when you're talking about Latisse and you're talking about Botox, which is historically billed by the unit somewhere between $10 to $15, and we aren't separating out those charges. We also don't have the pressure from knowing that we might have to prove ourselves out at some point. So I think that additional level of detail and having them truly separated and itemizing that for transparency for patients is really brought on by the pressure of the industry and the pressure from these manufacturers. And so that's where I think you can get into wearing both hats.
It's kind of like a CYA type of thing.
Yeah, like for Botox, the industry is 10 to 15 units, or $10 to $15 per unit is pretty standard from what I've seen. And you don't have the same need to CYA when it comes to, okay, here's what I charge. How people reflect their additional experience for Botox is they just up their unit charge, but not necessarily the same need to go into detail on the invoice for transparency for patients, because you don't have the same like outside pressure. In this world, I would absolutely, like in the GLP-1 world, I think you have to CYA in your charting. You have to CYA at every single step, where I'm like, okay, imagine this. We're in front of your board. I'm representing you, and we are proving out that you provided excellent patient care to this individual. What would you need? You need good charting, you need good consents, good transparency in your pricing, to show that you are not profiting from pushing them to one medication versus another. Like, I have practices that I work with that prescribe both medications, compounded and the ones covered by insurance. But the cost to work with you should be the same regardless. And that's, I don't think that you know, 10 years from now, we won't be doing that because we won't have this outside pressure in the world of medical aesthetics, in cash-based businesses. We'll still be doing it in insurance billing-based businesses. That's because it comes with all the federal regulations.
What do you think about hormone replacement therapy? Because that kind of goes hand in hand with medically assisted weight loss. We're seeing a lot of people coupling those two. Do you feel like there will be any pressure on, because there's a few main companies in that as well, and there's also compounded, right? In the way that people are helping. So is that, if we're trying to be kind of future oriented, and how can we be less risk averse, or be less, have less risk in our business without closing it? Are those things that we need to be looking forward, or is this just very specifically a GLP issue because of the shortage list type of thing?
I think this issue specifically is more related to the GLP-1 problem because you've got such big players who are protecting their patents at what it seems at all costs, and they're coming at it from every single angle. From the hormone replacement side, what I think the biggest risks on that is more often than not, it introduces a controlled substance because testosterone is a controlled substance. So making sure that a practice is compliant in how they see their patients, who's seeing their patients. And then I think the risk, on the spectrum of things that we offer in med spas, with a facial being the lowest level of risk. It's a controlled substance for various reasons, but it does come with some additional risk to patients. So the biggest thing that I've seen for providers is that they are taking some one-day course on hormone replacement therapy and thinking that they've got it on lock. And you're like, you have to defend that you prescribed the right concoction to this patient based on their blood work. And do you feel confident in your skills and ability? So I've seen some kind of concerns from that area, and I've heard concerns from nurse practitioners who their practices have asked them to just roll out hormones, and they're like, I don't feel comfortable because I am in the med spa space. I am not in the functional wellness space. I'm not treating people who have Hashimoto's. That is not something I'm comfortable with within my license. And that, as a business owner, as a non-licensed business owner practitioner, I have to be really respectful. If one of my providers that works with my company says that, that's within their scope to say, I don't feel comfortable. I need additional education or additional training to be able to treat patients. Because what they're essentially saying to me is, I don't feel, if you ask me, is this the right treatment? I don't really know. I don't have any clinical reason to back it up because I'm not educated on it enough. So that's the biggest risk I see for HRT is we're really getting into functional wellness and making sure that our providers are comfortable with functional wellness, especially if you're going from strict cosmetic and they do filler and Botox. Now you're talking about real internal stuff. And that is a very different business model, which requires training from the top down. Whoever's, your medical director, your nurse practitioner, your RN, whoever is helping in that field. It's a new service offering.
Anything else that I'm not asking about GLP-1s that you found in your research and trainings that you've been working on?
Yeah, I think the thing that's been discussed pretty recently goes back to, okay, so now when I finish the talk and someone feels comfortable, or they don't, they make that business choice, okay, one way or the other. Okay, so now they make the choice that we're going to continue. Now, where can I get it from? So we know we cannot get it from a 503B pharmacy. It is very clear that 503B pharmacies cannot produce that. And that's the pharmacy that produces in-office use, big vials. They have it on the shelf. You call them up and you order 12. Cannot do that anymore. But what we can do is a 503A pharmacy can make a patient-specific medication. So if you call up a 503A and say, I need to order a medication for Courtney Walker, oh yeah, we already have one ready. No, that's impossible because you're supposed to make it for Courtney Walker. So where can we get it from, I think, is a huge issue. How do we vet a pharmacy? How do I make sure it's reputable? I go to their website and they don't have an about me section. It just started yesterday, and you can only order over the phone, and they don't send you any type of email confirmation. Seems pretty sketchy to me. So vetting the pharmacies and knowing that where you can get it from as far as like pharmacy versus, I have a lot of questions about research-based labs where you get these, not just GLP-1s, but you get other peptides and it comes to you in your office and it says not for human use. Can you use that on humans? And I'm like, no, you cannot. The FDA is pretty clear as a provider where you can get medications from for human use, and for peptides, which includes GLP-1s, you need to stick to 503A pharmacies and steer away from research-based labs. One, because you're not allowed to get them there according to the FDA, but two, tell me this argument. Like, think forward. You're standing in front of the Board of Medicine and you're defending a negligence case.
Something that says not for human use.
On why you used not for human use medication for humans. Like, I am not, unless you want to pay me a lot of money, I'm not taking that case on. Because it's all what it comes back down to. You have to have good clinical judgment and sound clinical judgment and feel really confident in your decisions, which is why I am beyond passionate about the practice of law. I get really fired up about it. I put my hand up and swore an oath to protect the Constitution, and I will not let an outside business tell me that I can't represent my client the way that I need to represent my client. Now, if my own board tells me that I can't do that, okay, sure. They control my license. I'll listen to them. But I can't imagine Microsoft all of a sudden coming in and being like, no, you can't do that for your clients anymore. You're not allowed to represent them in that way. I'm like, this is my license. And I'm going to represent them in the way that I see fit and according to the board that governs my licensure in the court system. Like, you have no say in this. And that is essentially what is going on here, which is why I just really lean into like helping practices and providers protect that, because that's where we get into good medical judgment, good medical outcomes for clients so far beyond med spa world, like all the way down to hospitals. We don't want business to come into medicine, because that's when we can taint. That's cynical, that's skeptical, but I have a license to do that. That's where business comes in, and it can really, really mess with stuff, because so often people stop thinking about what's best for the patient or thinking about the best treatments. And they're then going into like, what makes the most money, or how do I profit out of this the most? And that's why we have so many laws and regulations, corporate practice and medicine, clearly delineating the two, because and even for medicine, for law, there are other professions where we want to make sure that the end person, who's the patient or the client or whoever, that we're protecting them from kind of that infiltration of business in a lot of ways.
This was so much incredible information. You are just brilliant, my dear. Thank you.
Oh, thank you. I could go on and on. I mean, and I have for months. It's like the number one thing what people want to talk about, but it's totally fine. And I get it. And then I have people who, because, one of the things I said at the beginning is I want the best thing that someone could say to me is that like they feel confident in their decision, whatever that decision is. So I want people to put their head down at night, and maybe they get a letter down the road, but at least they're prepared. They know the risks. They've made a very calculated and intelligent decision for their business, and just giving them that confidence is like, I feel like truly that's one of my purposes in life, is to help businesses navigate kind of a Wild West, a gray area in medical aesthetics in so many ways. But there is a way to do it where you don't go to sleep every night being like, they're coming for me. They're probably not. Yeah. But even if they do, we will have, like, I'm from Tennessee, so we will have a cheese board ready and some sweet tea. And you'll be like, welcome party, roll out the red carpet, come in and see whatever you want.
Oh my goodness. Okay, so where can people find you, follow you, stay in touch with you, get into your world? Where's the best place?
Yeah, I think the best place is on Instagram for the most like live action content. It's court approved aesthetics. I do a segment that people really enjoy a lot. It's called Whiteboard Wednesday, where I just pull out a whiteboard and start. You heard it here some, like doing charts, and really, I'm a visual learner, so really breaking things down. Obviously, all that's for free. And I try to do like legal updates and stuff over on there. And then if anyone's ever interested in working with me, then it's courtapprovedaesthetics.com.
Wonderful. Well, we'll get all of those links below this episode. I so appreciate you and your expertise, and this was such an incredible episode. Be sure to check out Court Approved Aesthetics. And of course, if you want to keep this conversation going, head over to the Spa Marketing Made Easy Facebook group, and I'll catch you on the next episode.